Next, I would like to welcome the Citizens Juvenile Justice Panel, featuring Leon Smith, the Executive Director, and Sana Fadel, the Deputy Director. Welcome. Thank you so much for joining us.
Thank you.
Good afternoon, Chair Creighton, Vice Chair Creighton, and video, and members of this committee. Thank you so much for inviting us to present to you today. My name is Sana Fadel. I'm the Deputy Director at Citizens for Juvenile Justice, joined by Leon Smith, Executive Director. We're going to be, again, I actually appreciate you talking about and looking at the prevention aspect of juvenile justice reform, where it's when we look at it, it's the first step in finding ways how to narrow the entryway of children being funneled into our legal system, where it's used as an alternative supporting kids who could thrive with more community supports. I will, as Leon is talking, we have some handouts that I'll pass on, make it easier to follow when we have like numbers and.
All right, so when we think about prevention and the overall benefits of keeping young people out of the system and addressing their needs in their communities, we have to center addressing the school-to-prison pipeline, and really what that means at a time where we've seen vicious attacks on public education and where many of our students come from backgrounds that are being, quite frankly, targeted by our federal government. Our students of color, immigrant students, and LGBTQ+ students, many of whom are still struggling with the social, emotional, and mental health challenges that have persisted since the pandemic, are also having to endure in an environment where they are hearing toxic messages about themselves from their very own federal government. Right now, our kids need more support to ensure that they can achieve academic success and thrive in the future. And if we continue to over-rely on discipline, exclusion, and system involvement as a remedy to their struggles, we're going to eventually see a descent from our status as a national leader in education, and we're going to see a generation of young people on a negative pathway. Again, and I say this respectfully, we cannot allow our belief in our own exceptionalism to blind us to where our students are right now. 5 years removed from the pandemic, Massachusetts had worse learning losses than the rest of the country, with our declines in both reading and math scores exceeding the national average, and our rate of recovery being less than the national average. We had the largest widening of our achievement gap, with the widening between poor students and affluent students wider now than it was in 2019 before the pandemic. And our literacy rates continue to plummet, with less than half the third graders reading at grade level, and more than 3/4 of our low-income, Latino, and kids with disabilities not reading at grade level by that benchmark. I drive home that point because not reading at grade level by the end of third grade is the canary in a coal mine, not just for education, but for public safety. The seminal study, Double Jeopardy: How Third Grade Reading Skills and Poverty Influence High School Graduation, found that students who don't read proficiently by the end of third grade are 4 times more likely to leave high school without a diploma. And once those students drop out, research shows they become as high as 8 times as likely to end up in our justice system. So as we look at ways to stem this educational regression that we're having, the conversation just can't stop at curriculum. Yes, we need to do more to promote learning recovery and literary success, and I commend the legislature for their interest in legislation addressing how we teach students to read. But even if you improve curriculum and teaching methods, our kids cannot learn if they're not in school, and they cannot catch up if they are continuously excluded out of school. We have to strike a balance between addressing behavior and ensuring classroom time to address those academic needs and academic progress. Days of lost instructional time, research from DESE shows, due to discipline, are higher for our students that are struggling the most academically, namely our students of color, students with disabilities, low-income students, and English language learners. We have alternative ways to address student behavior, especially when nearly half of our exclusions from school, when you get into the data, are for non-drug, non-violent, and non-criminal conduct. We need to continue to prioritize those alternative pathways and support legislation like Senate 373, 376, and 368. These bills do things like aligning us with 11 other states and the District of Columbia in largely banning suspensions for kids third grade and younger. Again, seeing the crucial benchmark that the end of third grade is. Legislation that would really tighten up our discipline laws, ensuring when expulsion, which is a severe consequence, is only meted out for the most serious conduct and not as it is now being meted out to students with lesser levels of behavior, and legislation that would ban exclusion strictly on dress code violations, which has always been important, but is especially now that we have students who feel targeted from all sides based upon their religious expression or expressions of their sexual orientation and gender identity. I also have to say that if we're going to address this achievement gap, we can't just do it with narratives. We're going to need data. And we're not going to get cross-tabulated civil rights data from our federal government right now. We need to fill that void here on the state level, and legislation like Senate 373 and Senate 380 will ensure that we publicly have access to cross-tabulated data, looking at intersections between race, income, English language learner status, and disability. And that the districts actually use that data to address disparities both in discipline and in academic outcomes. Lastly, when we talk about need and our most vulnerable young people, we really have to center the needs of our foster care youth. We can't just subscribe to the idea that once kids are removed from their homes and placed with the state, that they're better off, because research and data placing us at the bottom of the country and outcomes for that population says otherwise. Foster care youth have the largest disparity in dropout rates, 7 times that of their peers. They're 4 times as likely to be excluded, and they churn through multiple schools per year at a much higher rate than their peers. We can't allow this, this population, to be invisible, and we have to center and prevent those needs.
So Leon explained some of the drivers focusing on the school to prison pipeline and talking about a little bit of the cradle to prison pipeline that leads young people into our juvenile justice system. I'm going to be focusing on the how. What can we do in the legal system to address some of those you can't control, we can, as the legislature can control what comes in the front door, but you also can control how the juvenile justice system responds, make sure that the system itself does not perpetuate the harm that has led them into the system. So you have some data in front of you, so I'll share some of the highlights, but not. So you'll see overall, from 2018 to 2024, the overall caseloads and involvement of young people in the juvenile system has dropped numerically. But what the aggregate data hides is where you can see where have been some of the troubling increases. They've tended to be around more young people coming in for misdemeanors, more young people who are DCF involved coming into our juvenile system. So I'm going to talk about some of the front door area. The front door to the juvenile justice system. So the first front door is typically law enforcement contact. And so whether that is in the school or in the community, that's typically the first entry point for young people. So we want to make sure that that first contact, whether it's a field interrogation on observation, commonly known as stop and frisk, or having police officers in schools, or an actual arrest. So regardless of, those are all entry points where there's interaction between law enforcement and children, and we want to say, well, what does that mean? So the first area that you can look at is what information does law enforcement get out of kids? So when we have interrogations, for example, when there's an investigation into a case and that young person is a suspect, the juvenile system is unique compared to the adult system, is there's an interested adult rule in our mandate, because young people cannot figure out the system on their own. You need to have an interested adult. Typically, it's a parent. What we also know is young people, because of their age and they're two to three times more likely to falsely confess to a crime than an adult. A false confession on its own carries way more weight, even if all the evidence contradicts that confession. So you have a lot. So some of the factors include that they don't understand the consequences. They're much more likely to. They're much more vulnerable to police interrogation tactics, which are perfectly legal, like lying. I have evidence. Someone said something about you, but shouldn't you say something because they told you about this? One we typically hear is, just tell us and you'll go home, which they have no authority to make that decision. Also, they don't understand Miranda rights. 1 out of 5 young people actually understand it. Your right to remain silent. Well, if I don't say anything, I'm gonna get in trouble. To ask for an attorney, if I ask for an attorney, does this mean I'm saying I'm suspect? So a lot, and even with parents, typically an interested adult is a parent. 42% of parents don't understand their Miranda rights. And then sometimes there is a conflict. I'm a mom, I want my kid to tell the truth. So sometimes I will say, tell the truth. Because as a parent, I was not given a law lesson about the Fifth Amendment. So you'll see, so one of the things we're looking at is like what kind of supports can young people have during that interrogation, whether it's having a right to an attorney during that interrogation, to make sure that what you say, you understand the consequences, you understand the questions, you actually know what you're going into, and you can make a decision. Or even prohibiting the deception by police for young people, because ultimately, it's not about catching someone, it's about knowing what the truth is. And if you're likely to have a child who is not going to understand it and give you false information, you're not doing your job. Another area which actually is very relevant to the question you had asked, Senator Crichton, is the information sharing. So once, and this is regardless of an arrest, so even school-based incidents, or up to an arrest. So once a child's interaction with law enforcement escalates to formal involvement, so again, whether it's stop and frisk, an incident report from a school or an arrest, that information is shared with state and federal law enforcement and other agencies. So in some cases, we have local law enforcement that have a collaboration with federal agencies, including ICE, and share that information willingly. But even in cities that are sanctuary cities, we have police departments that collect information and share it and input it into shared databases that are shared with state and federal law enforcement, most notably the BRIC and the Commonwealth Fusion Center. So that's one area. Another area is fingerprinting. If a child is arrested, our state chooses to submit all fingerprint records to the FBI. 3 states do not allow fingerprint records to go to of kids to go to the FBI. You don't have to. There's administrators' MOUs, but that's something that 3 states that we're hoping Massachusetts will be the 4th to prohibit submitting fingerprint records of kids to the FBI. And once that information is shared, what happens with it when it comes, the impact is whatever the current federal administration's priorities are, whether it's a Democrat or Republican or what have you, that information is shared. So if I can pull up the example you had, it could have been the fingerprint, it could have been because it was put in the BRIC. All of those databases, federal agencies now are buying and purchasing data mining and surveillance technology to be able to use AI to just catch someone earlier. And then the next, and then I do want to end with something we could do here also as well, which is the diversion piece, which was the main theme. I want to go back to the data that Leon talked about foster kids. I did not talk about foster kids anytime up to this point, because we do not have data around children who are DCF involved in our front door of our legal system, even though many of them, if they have a CRA or a current protection case, are in their juvenile courts. We don't know the intersection of foster, DCF involvement and juvenile justice involvement. We have a data bill on that. But what we do know is once they are in the care and custody of the Department of Youth Services. So, I have many papers. What we can tell you is DCF-involved kids aged 12 to 17 make up 0.6% of the child population. They make up 47% of kids who are detained by DYS pretrial, and 37% of kids who are sentenced and committed to DYS as their sentence. Did the math, that's 72 times their proportion in the population. Why is that? And this is why, like, looking at diversion, not just how to do diversion, but who is eligible for diversion. Senator Praiano, you had asked a question, what's the difference between a summons and arrest? One legal system difference is if you're summoned, you have access to clerk magistrate diversion. If you're arrested, you go straight to a delinquency filing without having that probable cause hearing. Another one is our pre-arraignment diversion statute uses adult system sentencing to decide juvenile diversion. So adult sentencing, adults at the end of a case decides, are you as a child, in the beginning, should we consider a community-based intervention or should we go through the traditional path? That's what the legislature chose, great, but are there ways we can tweak it? One of the big things is that if we are looking at the eligibility is based on the offenses. So Senator Crichton, the example you gave, she was 18, so she would not have been eligible, but one of the reasons she got in is she got arrested because it was considered a domestic incident. We're seeing that anecdotally, that actually there's a misinterpretation of the domestic violence statute that says family and household member. The law defines it as an intimate partner, but it is seen as, oh, it's any family member. So we see a lot of siblings getting caught, including kids who are in group homes because they're household members being caught in that. Oh, and you got charged with assault and battery, you're ineligible for diversion. So it wouldn't help because she's 18 and there's no pre-arraignment diversion in the adult system. But there is in the juvenile system. So we're looking at the offenses, we'd argue like, oh, well, assault and battery, that's a bad thing. Or when we look at it as in terms of offense, then we say, well, do we really want to give these young people a free pass? Well, we have to look at it, well, who are these young people? When they come in, young people, the assault and battery is probably the number one charge in juvenile court. And it ranges from, sorry, boss, non-consensual touch is an assault with an object, that's assault and battery with a dangerous weapon, because this weapon has the potential of causing serious harm, not because the weapon itself is dangerous. That is one of the most sticky points for us to get it. And for those young people, I think to the panel prior talked about this, like young people need, like, how do you work with conflict? How do you deal with some of the issues you're feeling with? Getting locked up and getting a juvenile record is not what's gonna help you. So I'm gonna pass it, and just for the DCF involved youth, I do wanna mention, there is this intersection where they are coming in for these low-level offenses. In addition to the type of offense, when we're looking at who's detained by DYS, they tend to be younger. When you're the 12 and 13-year-olds, 75% of them are DCF involved compared to older. So they tend to be between the 13 to 15-year-old range, where the non-DCF involved kids tend to be the older half of the system. They come in, 60% of them are coming in for low-level offenses. They're much more likely to be held on cash bail and for low amounts, including $1, than for dangerousness. So I do want to pass it on to Leon to wrap us
just
up.
in tying up some of these threads from both Sana and Ms. Dregill on the previous panel, we really have to think long and hard about the impact of arrest and involving people in the system. There was already decades of research showing that arrest and system involvement leads to increased likelihood of dropout and an increased likelihood of further system involvement, whereas conversely, diversion leads to less recidivism and overall better outcomes. But in this current climate that we're in, with the realities of federal immigration enforcement, we now run the risk of not just a prison pipeline or a school to prison pipeline, but a school to prison to deportation pipeline. Using the example of the recent case in Everett where a 13-year-old child, a choice was made to send that young man into the legal system. He ends up being taken away and whisked out of state without ever having an opportunity, a due process for the allegations against him, and without those interventions that perhaps could have prevented things from escalating to that point anyway. And once these young people are in immigration detention, there are no interested adult protections for young people in those settings. Immigration enforcement is civil. There is no right to an attorney or counsel. And from immigration attorneys that I have been talking to for months, there are incredible abuses happening in those settings. It is not a place for a young person. So obviously there will be certain very serious offenses which have to go into court. But the old days that I think back to in the early 2000s when I first started as a lawyer, where officers would say, well, we just arrest the kid and let the court sort it out. The decision to send that young person into the system already posed consequences, and those consequences are much more grave, and that just gives more gravitas to why we should consider these reforms. Thank you all.
Thank you. Really appreciate your testimony. Leanne, you talked a bit early on about how harmful days of lost instructional time on our youth. You mentioned expulsions, suspension fall in this category. What are some of the other causes for students, I guess structural systemic causes for students to miss school? Is it time in court? Is it, obviously time incarcerated? Are there other impediments to them getting, the education that we want them to have?
Absolutely. So when you have a young person who is dealing with trauma, a social emotional issue, or a mental health issues for which they're not getting treated, far too often we see those young people continuously excluded from school without the adequate steps being taken to really get to the center and core of what the issues are and treat those root causes. So you have days of lost instruction alone just from the 2-day suspension, the 5-day suspension, the 3-day suspension, the 10-day suspension repeatedly over and over and over again. And I can tell you from my own practice as an attorney, stepping into those settings and being the first person to ever bring up the topic, have you ever looked at why this keeps happening? And so we really need to think about further embedding our schools with social, emotional, and behavioral supports, restorative processes, because those get to the why behind the behavior and not simply punishing the behavior and sending kids out. Now, once kids get into the system, certainly, cases can string on for a long time. It's not just the arraignment. You have an ongoing discovery process, multiple pretrials, a lot happens. A kid is missing time out of school for each one of those. And then there's the overall psychological impact of you're never trying to center a kid's needs and you're only punishing them. As kids get older, school goes from a place they're excited to go to a place they don't like going to. So, one of the collateral impacts of just repeated suspensions is you eventually see increased likelihood of truancy because kids simply don't feel welcome. So it's a combination of factors connected to both exclusion and system involvement, which leads to less time in the classroom, which ultimately leads on the pathway to drop out, and that's only going to lead to more system involvement.
Thank you. Just to build off that a bit, over the weekend I was speaking to a local educator, and they were talking about how, and I was unaware of this, that they moved away from detention, suspension, expulsion almost completely. They were kind of complaining about it, but in this instance it seems like getting to the why, that would be an important step. The previous panel talked about some of the geographical disparities we have. Is that the same in terms of how our school districts or individual schools treat these type of learning losses? I mean, are there places that are doing it really well and places that are doing it poorly? If you could offer any examples or your thoughts.
Absolutely. If you go to our website, we look at the 50 largest school districts in Massachusetts, and we look at where the disparities are. And again, that's data that we have to request from DESE. And then we cross-tabulate that data and we show it. And there, of course, statewide, we have these disparities, but certainly there are some places that have wider disparities than others. And to me, key differences are under parts of our exclusion law, 37H and 3/4, for example, which covers exclusions based upon violations of school codes of conduct. There's a requirement that alternatives be attempted and documented prior to an exclusion under that section. How much resources a district puts into funding those alternatives so that they're done effectively, that often varies. So at some point, the legislature should consider, we've required these alternatives, but is there adequate staffing? Is there adequate training? Restorative justice works. It works in communities, it works in schools, but one of the key things behind the effectiveness of restorative justice in schools and the victories we've seen in places like Oakland, it's not just an initial training, ongoing professional development, and is having an adequate number of restorative coordinators who can be there for school staff and be there for teachers and be there for administrators to advise them and guide them and really implementing it with fidelity to the model. What we find is that there's some districts who have restorative justice in name only. It's only used responsively. It's not used as it should be as a preventative way. The idea is if Leon and Sana aren't getting along on Monday, and by Wednesday they're arguing and they're going back and forth, restorative justice should be pulling Leon and Sana in and getting to the bottom of what the issue and the problem is, de-escalating that. If there's been harm, addressing it. In the absence of that, Leon and Sana continue to go back and forth. They continue to send messages on social media, and then on Friday, Leon and Sana are fighting, and everyone says, oh, I gotta fight. If we properly staffed and implemented, we're able to de-escalate, again, getting to the root rather than just responding once something happens.
Thank you, appreciate that.
Yeah. Thank you, Mr. Chair. Thank you so much for your presentation. I just wanted to touch on your last two graphs. So if you can, one, talk about a pretrial detention. What's the difference between low severity and high severity? And we'll start there, and then I have a questions that we'll follow up.
I forgot to keep a copy of myself. Is that the one with the orange, green, and green?
Yeah, it's this one up here.
This one, okay, got it. Thank you so much. There's, so DYS has something called grid levels. So grid level 1 through 7, 1 through 6 is within DYS's jurisdiction. So 1 and 2, DYS considers low level. This includes assault, like simple assaults, shoplifting, trespass. Then there's medium, which is level 3 and 4, and then there's serious, which is 5 and 6, which is like things like youthful offenders, things that are like weapons, serious bodily injury, things that are like more serious. So what they do is when they detain young people, they know what they're coming in for, and they know what's the most serious offense that they're coming in for. So that data, when they report on like who's in their care and custody, they will also include the severity of the offense. And so that's what that graph, that's how that is, how that data comes in.
And just to build on just the troubling increase in low-level offenses that are coming in, when you look at the increase in the utilization of detention, it's largely driven by low and mid-level, with low-level offenses being up 21%. So we're detaining young people for misdemeanors, but then ultimately, the overall majority of these young people, 87%, don't result in a commitment. And then a high percentage of those cases end up even being dismissed at the end of the day. So when I look at, here's a misdemeanor, and this kid is in the system, entangled in the system, and ultimately it's not a commitment, and in many cases it's dismissed, isn't that a case we could have just sent to diversion in the first place? Like this stubbornly old mentality that just sending kids to court is a fix The research doesn't back it, the numbers don't back it, and yet we're falling back into that pattern, unfortunately.
Thank you, Mr. Smith, because that was going to be my next /point question. I think it might be important for the members of this panel to talk about what is pretrial detention.
Yeah, so pretrial detention is your case goes to court, you are arraigned, and there's a bail argument at that point in time. A judge can release you on your own recognizance. You go home with your parent until the next day. A judge can release you on certain conditions, or a judge can choose to hold you in Department of Youth Services custody until the next court date, or in some cases for serious offenses for an extended period of time. It's you as a kid are going to be sitting in detention, away from home, your education disrupted, waiting while your case is pending, as opposed to being in your community and at home where you still can go to school and you still can access those community resources you may have.
Thank you for that. And I think it's definitely sad to see that there are so many cases that are where children are being detained. And by being detained, while DYS is a lot different than our adult system, they're still in a secured facility. They're still, they're inside a cell. And what one of the other panelists mentioned, so I was a teacher at DYS, and there was a time where I decided to spend my own money and decorate my classroom. And when the kids came in, the first thing they said was, "Mr. Fadel, what do you think this is, a school?" And that shocked me, because I was like, yeah. But it helped me understand that before I was able to even try to educate the youth, I had to get them into the mentality that they weren't prisoners, that they were students, that they were young people, that if they focused, once they got out, they'd be able to obtain whatever it was that they wanted to be, as long as they put the work in. But we had to sort of work on that prison mentality where they saw themselves as criminal and everything was transactional. And what's hard, because I think that there is this belief that these children being detained, that they'll be able to get services while they're being detained, which is true. I think, I don't know about they get something while they're being detained. It's not the same as the type of services that the kids are being committed get, but they get some types of services, but they're still locked up. And there's nothing like how detrimental that is for, never mind an adult, but for a young person, than being locked up, especially for a low-level crime. Can you talk a little bit about, because I think it'd be important to talk about class and race and how this affects whether someone is in pretrial detention?
Yeah, absolutely. So to your point, detaining a kid has a mental health impact, because you're detained, you're away. It has a huge impact on self-esteem. When a young person comes out, you're dealing with this level of stigma from having been in there. And again, being here and having a robust diversion system, they're in the Department of Youth Services where you're right, they're getting something, but they're not getting the level of assessment and connection to community-based services and resources that they're getting in diversion right now. That 80% success rate, speaks volumes. But you mentioned some of the racial disparities, and I'll just quickly run down. So Black and Latino youth are more than 5 and 3 times likely to be subjected to a custodial arrest rather than a summons, and 4 and 2.5 times as likely to be subjected to an application for complaint into the juvenile court. So right there we see, and again, to the prior panel, the decisions that adults make. You have diversion sitting there. They're more likely to be arrested, and to Sana's point, you just go right into court, as opposed to being summons, where anytime I had an opportunity as a lawyer to go to a clerk's hearing, I would go, because even before we had diversion, Our clerk magistrates have always been very reasonable at exploring alternative ways to address cases rather than sending them to court. For years, letters of apology, community service, you're able to do things, or simply argue against whether or not there's probable cause at that. That decision point makes a difference. I always talk, even if it goes to the day of arraignment, you're going before a judge. Are you going in there in handcuffs, wearing what you had when you were arrested, or are you going there dressed appropriately, walking in with your parent? The optics in court matter. So that decision to arrest or not arrest matters. That decision to send the case into court matters, because to Senator Crichton's point, simply sending something to court, we're seeing that trigger other impacts. And when you look at detention and our rise in detention, you see detention is up far more for Black kids, 14%, and Latino kids, 22%, than it is for white youth, 9%. So we're seeing at these decision points, there's certainly racial disparities, and those racial disparities at the front door persist throughout our system.
Thank you. How long are, sort of like, what's the range of kids being detained as far as time?
Do we have
Is there an average? If you don't have that info, that's fine.
It keeps going up.
Yeah.
I want to say I'm looking at Melissa behind my eyes, 66 weeks?
Yeah.
66 days.
66 days.
What
What is the longest that you
gosh.
think of a child being detained?
My God, months and months. For serious offenses, kids can be incarcerated 3-4 months, even longer sometimes. So it really varies. Sometimes, and this shouldn't be happening, but some judges still do the whole, I'm gonna hold you for a couple of weeks and come back to teach you a lesson. It doesn't teach a lesson. So you have some shorter, but on that average, you have some kids that linger much longer. And so again, I say, beyond just that mental health and psychological impact, is coming out with that stigma. If you go into detention in October and you come out in May, and you've got to try to reintegrate back into your school, chances are you're not going to do well. It has all these collateral, the idea that, well, detention is just something that we can use to turn kids around and help. There's so many collateral impacts where it hurts.
And also 58, like, if they're held on dangerousness, so no cash bail, it's a minimum, it was 180 days, 120 days, 180 days
180.
minimum, but that doesn't count like all these other continuances, so it can go up to over a year, right?
Yeah, absolutely. And this is to say there are certain serious cases like under dangerousness that have a serious implication for public safety where, yes, we understand detention is being utilized. But as we see mid-level and low-level offenses, the type of offenses where diversion has been accepted continue to be pushed not just into the system, but I refer to both detention and commitment as the deep end of the system. We are not helping our young people or public safety by having kids with low-level offenses reach the deep end.
So my follow-up question to that, now that we've talked about that a lot of individuals, a lot of young people that are being detained for low-level offenses, and we talked about 87% of the folks that are detained don't result in a commitment. I'm interested in knowing more about the individuals that it does result in a commitment. Now, in the adult system, if you are detained before you are judged to be guilty of a crime, the time that you are detained is taken into account when sentencing occurs. Could you talk to me about if child's been detained? I mean, I saw some students being detained for over a year. Let's say a child is detained for a year and their case is being heard. Is a judge able to take into account the time that they were detained as they think about or they have a judgment as to how much time this individual is going to be committed for?
there is no credit for time served in the juvenile system. So as someone who practiced both in our juvenile courts and in our district courts, you're absolutely correct. If at a certain point in the case, there is a plea in the adult system and that person pleads to 1 year in the House of Correction, they have been in detention for 4 months until then, the judge will give credit for time served. So that person is only looking at 8 months. The way our juvenile sentencing structure is, a commitment to the care, custody, and control of the Department of Youth Services is seen as being you are committed for their oversight, treatment, and care. So you are basically in DYS's custody and care up until the age of 18, or depending on certain cases, 19 or 21. So once you're with DYS, sometimes you're in a secure, sometimes you get a grant of conditional liberty to be back in the community, but because it's seen as treatment and not a hard, specifically time sentence like the adult system, they do not get credit for that time. And I will tell you, I spent 18 years representing young people. That is a major complaint for young people. Young people consistently talk about dead time because they're aware of, in the adult system, they get credit, but here I'm just sitting and wasting time, and it has an impact, because at the end of the day, I'm a big believer in zealous advocacy and the fact that every young person has constitutional rights, including the constitutional right to a trial. There are absolutely young people who say, just let me plea out, rather than just do all of this dead time, which ends up building a record and pushing a young person deeper into the system.
So I think you brought up some really good points. In particular, that if a young person is like this, I might be in detention for 9 months to a year. If I plea out, I might get 9 months to a year. Should I just plea out? Or you might have individuals that serve a year and then are sentenced a year and now are doing double the time for the same offense. Now, is there any sort of pushback from like judges, DYS, or like I'm trying to like understand like the logic behind wanting to, and I know I'm trying to have like play devil's advocate because we heard from you as to why perhaps that system should be shifted. Can you give me any thoughts into what the opposition might say? Like, why would they want a child to be in youth jail?
It's interesting. So when you look at our structure, it's purely intended. It's intended with the idea of we're committing this young person into the system, and the Department of Youth Services is charged with assessing that young person, figuring out their needs, and coming up with that treatment plan. That treatment plan may be of varying lengths of time. And so we don't have determinate sentences because when I started my first year of practice, I practiced in Rhode Island. Rhode Island did not have this type of system. They had determinate sentences. And so you could say under that system, it's easier to factor in time served. 6 months, you've been, locked, you've been detained for 3, you have 3. But then the argument goes, okay, this young person has serious needs that would require 9 months of treatment. They only have a 6-month sentence. You're not able to really focus and center the rehabilitative aspect of it. So I don't have like a hard place to come down because I see the worldview in saying these are children. This isn't the adult system. We're not a punishment-based model, and our model is rooted on rehabilitation. And at rehabilitation, every young person is unique. It can take a short time, it can take a long time, and you really should focus on the amount of time that a kid, the thinking is, the focus should be on the amount of time that young person needs to be in treatment to be able to return to society. I just also, putting my other hat on, as someone who's been client-facing, have just heard the complaints from young people, and I've seen some of those impacts as well. So I see it on both sides.
I would say anecdotally, in my own experience, children are doing better in treatment than they do better than in detention.
Absolutely, absolutely.
I'm in dead time, none of this counts.
Once you're committed, you gain access to the treatment. But again, it's when you think about, having a charge on a carry and having it followed by not delinquent, or having it followed by dismissed, as opposed to DYS commit on that carry, there's that impact. I understand why a young person would say, I'm just gonna plea out and get on with it. But that's why we advocate for things like expungement, and having opportunities there, because young people do, and again, young people still developing, impulsive decision-making, thinking of the moment, young people making those decisions, but those decisions do have lifelong collateral consequences too.
Thank you. Thanks, Chair.
Thank you, Senator. Seeing no one with their hands raised online, give you one last opportunity if anyone joining us remotely wants to hop in with questions. Seeing none, I want to thank the panel for all the work you do on a day-to-day basis, your testimony here, and I'll take the liberty as chair to thank you for all of your help on raising the age legislation and all you did there. We'll
Thank you.